What might be the consequences of all of this? Earlier this year, extracts from my book were published by Vanity Fair, and I've learned a great deal more about the power of that publication. Within a few days of the article coming out, in early April 2002, the chairman of the House Judiciary Committee, Congressman John Conyers, announced a series of hearings that would focus on the role of senior administration lawyers. I've testified twice before the committee and once before the Senate Judiciary Committee. There have also been important hearings before Senate Armed Services Committee. Around all of the hearings is a growing acceptance that something has gone wrong and of the necessity to establish the facts and identify the people who were truly responsible for what has happened. More significantly, there's broad recognition, very broad recognition in this country and outside, that war crimes were committed in the interrogation of Mohammed al-Qahtani. You don't need to rely on my word for that. The Judge Advocates Generals of the Army, Navy, Air Force and Marines have testified before the US Congress, and when asked whether war crimes were committed, violations of Common Article 3, they unanimously assented to that view. I take my hat off to those rather brave individuals who adopted that view in that context. That cannot have been easy. It was an extraordinarily admirable thing to have done. You can also take the conclusion that war crimes were committed from an important judgment of the US Supreme Court. It's already been referred to today. In June 2006, the court famously ruled in Hamdan versus Rumsfeld, on which you've heard so much already, that the President and the administration had simply got it wrong. The Geneva Conventions did apply at Guantanamo, including Common Article 3. All of the detainees, Al-Qaeda, Taliban, everyone, had minimal rights under that provision. And the ruling opened the door to war crimes allegations, a point that was raised powerfully by Justice Kennedy in his concurring but separate opinion. He raises the spectre of war crimes. 4 months after the administration received that judgment, it pushed through the Congress the Military Commissions Act of 2006. Buried in the heart of that legislation is a provision purporting to grant immunity to persons associated with all these techniques of interrogation. There can be little doubt in relation to al-Qahtani, and no doubt perhaps of many others also, that war crimes have been committed. Who's responsible for these war crimes? Can the lawyers be responsible for them? And that, of course, brings us back to the film Judgment at Nuremberg and the trials which underpinned it. I thought it'd be interesting to find out a bit more about what exactly it was that Joseph Altstädter had done. He was the lead defendant in the justice cases. And I did everything that I possibly could to get hold of as many of the documents in the case, the written pleadings, the oral arguments. I got great help from the archivist at the Holocaust Museum in Washington, and I did manage to track down a great deal of the material. But there were a number of basic documents I couldn't find. So I tried to track down some of the lawyers or their law firms or their successors who might have been involved in the case. I managed to locate, using Google, Ludwig Altstädter, the son of Joseph Altstädter. Ludwig Altstädter is a retired lawyer living in Nuremberg, and eventually he agreed to meet with me. To this day, Ludwig Altstädter believes that his father was wrongly convicted. He describes his father as an ordinary lawyer, reputable, who'd been to the very best law schools in Germany, who was deeply religious and had simply been doing his job in the German governmental service. He was, said his father, as ordinary a person as you or I. When I got to his law office in Nuremberg and went into the conference room, he'd carefully set out all of the original documents from his father's trial. It was quite remarkable. He had kept absolutely everything. At the time, in 1947, he'd been a 15-year-old boy, and he'd never talked to anyone about what had happened. He now wanted to do so, to get it off his chest. What I was looking for were a couple of underlying documents that I couldn't find in Britain or in the US or anywhere else, to understand the basis upon which Joseph Altstädter was acquitted of war crimes and crimes against humanity, but convicted of membership of an illegal organization, and then the crucial bit, with knowledge and involvement in its illegal acts. The judgment in his case was important because it established, along with the other cases, and he was by no means the worst of the individuals, far from it, but it established apparently for the first time in proceedings such as this, the principle that lawyers and judges in a governmental regime bear a particular responsibility in certain circumstances. Mr. Altstädter had the misfortune, because of his name, to be the first named defendant listed amongst the 16, and as I've said, he certainly wasn't the most important or the worst, although he was one of 10 of the 16 who were convicted. 4 others were acquitted, 1 committed suicide, and in 1 case there was a mistrial. he was a well-regarded member of society and a high-ranking lawyer. He joined the Reich Ministry of Justice in 1943, and he served as the chief of the Civil Law and Procedure Division. It was his membership in the SS, however, and his knowledge and involvement of its acts which were his downfall. The tribunal convicted Joseph Altstädter largely on the basis of two letters, which indicated his direct knowledge and involvement of the crimes of the SS. I took Ludwig the son to a striking passage in the tribunal's judgment in his case, and I quote, "He gave his name as a soldier and a jurist of note, and so helped to cloak the shameful deeds of that organization from the eyes of the German people," end of quote. I asked Ludwig whether he had copies of the two letters that I was looking for. He did. He went to the neat pile on his desk and dug out the copies of the originals. I still have them, actually. The first letter was dated 3rd of May 1944. It was from the chief of the intelligence service of the SS to Joseph Altstädter in his capacity as a lawyer in government service, asking him to personally intervene with the regional court of Vienna to stop it from ordering the transfer of certain Jews from a camp at Theresienstadt back to Vienna, where they wanted to appear as witnesses in a court case. The second letter was Altstädter's response of a month later to the president of the court in Vienna, and I quote, "For security reasons," he directed the judge in the court, "these requests cannot be granted," end of quote. Now, the US military tribunal in that case proceeded on the basis of those letters, that Altstädter must have known what the camps were for and what the consequences of his letter to the president of the tribunal in Vienna would have been. And on the basis of those two letters and the surrounding facts, he was convicted and served 5 years in prison. It was his claim to security reasons which jumped out of the page of that letter. Those are very familiar words. We've lived with them in Britain in the 1970s in relation to the IRA. You're living with them in this country in relation to what is going on right now. But they were remarkably similar to the words used by Jim Haynes when he spoke at his press conference on the 22nd of June 2004 to explain the circumstances in which he wrote his memorandum to Mr. Rumsfeld. And I quote, "Military necessity," he said, "can sometimes allow warfare to be conducted in ways which might otherwise infringe on the applicable articles of the Convention," end of quote. Mr. Haynes provided no legal authority for that proposition, and he simply cannot do so. Military necessity cannot be used to justify a departure from the standards reflected in Common Article 3, or indeed the obligations set forth in the Torture Convention.